minute. Let me just put out the conference, little bit on the conference, because I was telling someone that Martha had said that it would be nice to tell us what you're discussing, because I start off immediately. So this is the World Mediators Conference. The idea is to look at the Vision 2026 for the evolution of mediators and mediation. 18th May to 30th June. All sessions are live streamed. YouTube channel. You just search for Mediator Vikram, you'll find that. Otherwise, there's a website, mediatorvikram.com. You can find some details there. Of course, on social media posts, you can find details. So the sessions, you can participate also. The social media post has the schedule. So please do that. And we are discussing today colonization, decolonization, and mediation. So we're going to start now. So Jeannie, please introduce yourself. And this, I told you, I spoke to myself right now. In a way, it feels really funny, but this much I have to do. So Jeannie, please introduce yourself and let's take it forward.
Certainly. Thank you, Vikram. My name is Jeannie Zimmer, and I am zooming in from Minnesota. And I have been involved with restorative justice and community mediation for over 30 years, both in Minnesota and in the Chicago area. And my colleague, Victor Baba Jr. is supposed to be joining us, and so we have our fingers crossed that he will be here as well. And this topic is of particular interest to me, and Vikram, we haven't had a chance to really talk about this, so this will be, I think, a good opportunity. Community mediation really is this idea that everyone can use community mediation, but everyone can also learn the skills of community mediation. Everyone can be a mediator, and this includes, kindergartners and people from all walks of life. And my experience has been that these indigenous processes have been co-opted by people who look like me, and myself included, unknowingly, and institutionalized and I don't want to say over intellectualized, that's the wrong word, but really turned into something that they don't need to be. And that if we can get back to the origins, we don't need, 3 pages of an orientation, or we don't even have to, even the language we use when we say opening statement of the mediator, maybe it's an orientation, or maybe it's just a welcome. And do we have to have, all of the mandatory reporter and all these protective clauses in there? And it can really be off-putting for participants. And so that sense that we've gotten so far away from the roots of what this practice truly is, and how do we get back to that? How do we not have it be so co-opted by courts and systems? And it's really people helping other people.
So, Jeannie, what I'll do is, let me just put out that symposium that I did last year. I like to talk about that because this was exactly the idea behind this. So I'll just put out, this is of course available on my website, but let me just show it here because this is exactly what I've been talking about. So let's just have a look at what I said. I'm reading from there. So basically, I took the definition from the Singapore Convention because I really like the definition, nice and broad, a process irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of the dispute with the assistance of a third person or persons lacking the authority to impose a solution upon the parties. So this is where, for me, that is mediation. So then I said, mediation as defined in the convention has been part of our culture and traditions. It is part of our cultural heritage. So people around the world may not be familiar with the word mediation, but they're familiar with the process, and as it has been used from time immemorial. A collaborative approach to dispute resolution has been used by families and communities, including indigenous and business communities, for centuries and has passed on from generation to generation. We have to go back to our roots and move away from an adversarial approach to a dispute resolution to a collaborative approach. So we got insights. Okay, we have to spread awareness, and mediation is a process which is part of our culture and tradition and has worked for centuries and will work for us today. So this is the best way to promote it. And Victor is here. Victor, I'll just get you in a minute. Just a little introduction to because Jeannie has just spoken about how she has looked at mediation, the way it has gone, in the direction it has gone, the westernized version of it, as she kind of put it, not those words she didn't use, but the westernized version of it. So is that the correct way to do it? And the tradition, the indigenous aspect of it, that part of it. So we'll just have a look at what colonization and decolonization has done. So Victor, but before that, please introduce yourself and let's take it forward.
Thank you so much, Vikram. I'm so sorry for being late. I'm a little bit indisposed. The weather in Nairobi is kind of cold, and usually some of us struggle to transition from the warm weather to the cold weather. I think you can feel it in my voice. But nonetheless, I'm so happy to be here. My name is Victor Baba Emmanuel Aligo, and I am a mediator first, and I'm energized, I'm always energized to have conversations on colonization, decolonization, particularly in mediation, because mediation is a fairly young, I know you don't like using the word profession. So for lack of a better word, mediation is a young profession. And I feel that it can be perfected from other value systems. And I think decolonization is one way to perfect the practice of mediation. We're not saying that mediation in its current form, which is informed by Western thoughts, ideologies, and values is bad. But I think with the conversation on decolonization, what we're saying, or what we are attempting to do, is to see to it on how we can perfect mediation. How can we have a broader conversation on mediation? How can we bring on board certain constituencies of people who might not be well represented? So I'm really happy to be here, and I'm always grateful, Vikram, for the fact that you introduced me to new friends, and I'm happy to have Dr. Jianzima. Thank you so much.
Okay, so now, Victor, the only thing is that let's understand that everyone keeps saying conversations should start with the weather. In this case, we will not do that. I think we're going to stop that because I'm at 39 degrees centigrade. And when you say we're having cold weather, it's just like rubbing salt on my wounds kind of situation. Why am I not in Nairobi? That kind of situation. So maybe talking about the weather might not be the best thing. But I think the thing is that we were talking about it. But when you said it's a new profession, of course, that aspect we're going to be discussing later in the conference. But the important thing is that of course, we're also going to be discussing whether it's a way of life. With that, those are two separate discussions. But the important thing is that because traditionally it was maybe not taken as a profession. Again, I'm using the word profession. We'll discuss that. But if it was not taken like that, so that aspect of it, of course, the way it was practiced, how did this whole colonization, setting up courts, and in whatever way the colonizer wanted you to come to their institution for dispute resolution and whatever other divide and rule policies and everything. A lot of aspects happened with colonization. So how did that affect all that? So maybe we can have Jenny's stand to start up on that. I mean, let's just go back into history and look at colonization and effects on dispute resolution right from there, and then on mediation, and then we'll carry it forward from there.
Well, and it's so nice to meet you, Victor. We've been communicating virtually, but not face to face, which is terrific. And thank you, Vikram. So really, I think it was the annexation by the legal community, even just the term party, when you talk about people, I mean, these are people participating in mediation. Party is a legal term, so how much has the language of the legal system infused mediation? And the community mediators are really trying to say, to humanize it or rehumanize it and put the people back in the room. and to make it about their conversation, their relationship, not about an issue that needs to be settled. So it's, how are you approaching it? And it truly has been, you know, when the legal system saw that it could be more efficient, when you go back to the Pound Conference, things like that, that really, and I appreciate the legal community using mediation. I mean, I think it does work, but what you have then is attorneys who, or judges who don't always understand that it's a different hat that you wear, and it's, as you said, a different way of being when you're mediating. And I see it across the country where this is a very gentle art, and it's a very nuanced way of being with people and being genuine and bringing yourself into the room. You know, bringing the bowling, Hoffman, bringing peace into the room. And the minute that you are almost like have your clipboard and papers and putting people in opposite rooms and all of that is not really distances people from each other. It's their conflict, and it's really up to them to resolve it, or to, if they choose to do that. So I'm really saying that it was really the legal system involvement and the training that happens in law schools and in legal annexed worlds that has really a bright line between what then the community programs do. Now, I don't know, Victor and Vikram, if you see that differently, but that has been my experience.
No, definitely. I think that aspect is really important, but what I'm thinking is we'll come to this at, I mean, a little later. I just want to go back into history, because that's where Victor maybe is going to take us back into history, and starting from there, because one is the colonization. Why did I put it separately? Because colonization, all these effects of that. And when the decolonization happened, what did we do? How did we take mediation forward in various countries? Because obviously some countries are still waking up to it. Some countries have a lot of, maybe some have legislation. They have, of course, maybe a much more mature market. Let's call it mature market. So how did that process go through? And like you said, the lawyers coming in, and the whole system, maybe some countries revolving around them. How has that affected it? So we'll go through that. So Victor, you want to start right from the beginning?
Thank you. Maybe just to build on what my colleague Jenna has just said, traditionally, if you look at the legal profession, it has its history in aristocracy and elitism. So that's one thing we cannot run away. And to connect that to history, and I don't want to claim to be an expert on history, on African studies, but allow me to maybe just spell my mind on African history and colonization. Most African societies practice what I would call traditional indigenous dispute mechanisms, where the society as a whole participated when it comes to dispute resolution. And probably, I'm just making an inference, probably the African society had structures and institutions that would, train people on African traditional indigenous dispute resolution making avenues and forums where we had probably most voices represented. And there was a holistic approach to this. By holistic, I mean that all members of the society, women, elderly, were represented in some kind of a committee that would sit down and get to look at disputes that arise within the community. I'll just maybe make an inference to I'll make an inference to a penal or a crime scenario where if one member of the community was adjudged as being guilty, such a person would be banished from the community through a traditional indigenous dispute resolution mechanism, where, of course, we had I want to refrain from using the word petty, as Jenna had alluded to earlier on, where we had, every person, every disputant, would come on the table, they would place their evidence on the table, and a group would sit down. And this is a group of experts from the community. And this expert represented the whole community as a unit. And once they look into the facts, and once the offender is found guilty, they would be banished from the community. So this is to say that right before colonization, African societies or indigenous communities, for lack of a better word, had elaborate structures of dispute resolution. But now, how do I connect this to colonization? Now, colonization is if you look at colonization critically, you will come to the point of view that colonization was not only elaborate, but it was intentional, and it was multifaceted and multidimensional. There's a psychological approach to a colonization. If you look at the writings of great authors like Frantz Fanon, I don't know if you have read their work, Samir Amir, they all point to the fact that there was a psychological component to a colonization. And then we had an economic point of view to a colonization. And I think the economic fortunes that came along with colonization, you needed a legal system that would not only economic edifice of colonization. And I think this is where we sort of lost our traditional indigenous dispute resolution protocols or forums. And if you look at the Kenyan system right now and the Indian system by extension, we all subscribe to common law doctrines and common law jurisprudence. And what common law jurisprudence sort of did was that it not only supplanted these traditional indigenous mechanisms of dispute resolution, but it replaced them. And to date, we are still trying to reclaim our legacy that for quite some time has been informed by indigenous dispute resolution making protocols. So that's how I look at colonization. The fact that right before colonization, we had elaborate structures of dispute resolution. But with the advent of colonization, we sort of saw some of these mechanisms thrown to the sideline, and common law sort of took the order or the norm of the day. That's how I look at it, Mediator Vikram.
Yeah, because I think basically the idea was the colonizer wanted control, and their control came in because a few, when they are going to run a country, what else do? They create those systems, those institutions where you're supposed to come to. Don't go within yourselves. We are there. You have to come to us. So that kind of an approach, definitely. How do you otherwise? I mean, I think they were at one point of time, there were some 5,000 bureaucrats who were ruling over 300 million Indians. Because now today we have 1.3 billion, but that time there were 300 million. So that kind of a system that you had to create, of course, for them, definitely, I'm sure it was good. But like you said, the traditional systems went. So Ginny Hantu wanted to come in. Yeah, Ginny, please.
Yeah, and I didn't go back far enough in terms of the colonization, because obviously the same thing happened in the Americas, and with again, as you said, Victor, elaborate structures that existed in First Nations and American Indian populations that then were there was genocide and the eradication of those systems, and then the imposition of the colonial legal systems. So the same thing happened in the US and Canada.
Yeah, because I think the other thing why I said like decolonization was because the same laws were picked up. I'll give you an example. Victor maybe would give the Kenyan example, maybe the US example you can give us. But in India today, the Indian Penal Code is 1860. The Civil Procedure Code is 1908. We got independence in 1947. So what we have to look at is when decolonization happened, at that point of time, the new people who came in, who took power and started ruling, again, I'm saying ruling, started ruling, they saw those systems as good systems because few people could run the country, they could rule over the people. So that aspect also we need to discuss, that why are we not wanting to move away from that structure, whom does it benefit? And if we don't move out of that system, because of course Victor is going to tell us about the Kenyan example and what James Mangarelli is doing there, of course he's going to talk about that because he's strengthening the traditional system. So we have to be doing that, and maybe that should have happened when decolonization happened. Even if it hasn't happened, we can start today. So Victor, you want to go a little bit into that?
Thank you. One thing that happened when most societies that were under the regime of colonization decolonized was that we inherited, we inherited structures that were introduced by our colonizers. And this can be justified on a number of reasons. For instance, from an African perspective, you will realize that the whole concept of a state is foreign to Africa to date. We have yet to master what the concept of statehood is all about. So when most African population and most African societies decolonized, it was only fair enough that they adopted, what was introduced by our colonizers. And that's where the problem is, I think. And earlier on, I pointed out that there's a psychological element to colonization. And until we get to speak to that, because what colonization did was that it demonized, for lack of a better word, it sort of watered down one system, at the expediency of another system. Yeah. So when you put these two systems together, at the end of the day, everyone wants to go for this system that has been, for lack of a better word, glamorized. We have sort of glamorized Western systems over other systems. And we see this in everyday life. I'm a student of international relations, peace and conflict studies to be specific. And I'm sure at some point, Dr. Jen will maybe second that today our international relations as we know it is largely informed by Western values. And all these trace back to colonization, because what colonization did was it sort of demonized one ecosystem and uplifted another ecosystem. And that's why we're having these imbalances. That's why we're having these imbalances. You just need to take a critical look into our higher learning institutions. And you don't need to be a rocket scientist to come to the conclusion that our higher learning institutions are largely informed by Western forms of education. I'm not saying that they are bad. I'm not here to insult Western values. Of course, I have benefited from Western values, from Western thoughts, from Western ways of looking at life. But looking at things from a colonization, you just have to allude, or you just have to struggle with the fact that what colonization in essence did was that it lifted one system at the expense of another system. That's, and if I take a look at my society right now, we are an extremely litigious society. Everyone wants to run to the court because we sort of see litigation as a high-hanging fruit, and mediation and other traditional indigenous forms of dispute resolution making as low-hanging fruit. And that's the legacy. The fact that we are able to see litigation as the ideal thing at the expense of other forms of dispute resolution, that tells that colonization is still alive today. The legacy is well alive today. And I'm glad that we're having this conversation, just to deconstruct and look into what colonization was all about.
Well, I think the important part, like you said, is that this whole concept that dispute resolution has to happen in courts and lawyers have to be involved, that conditioning over hundreds of years, obviously, has to be changed. And how it's going to happen, of course, we might not have solutions right now, but at least that discussion we can start. But I think the important part starts from the aspect of community. That destroying the community was also one of the aspects of colonization, because like I said, divide and rule is the only way you can rule over the large population. How do you do that? How do, like I said, 5,000 people ruling over 300 million? So you divide communities, you destroy communities, and dispute resolution at the community level gets destroyed with it. So one, of course, in relation to decolonization, if we take the same system through, that community strengthening doesn't happen. So that community strengthening aspect also, because we have an example with us. I mean, James Magarere, what he's doing in Kenya and other things you might have seen in Kenya is such a good example of that. How to strengthen it. Of course, there are issues in the traditional system also. Of course, there are people who will tell you what to do and force you what to do. That's not mediation. So we have to distinguish that aspect also. Not take it with us that, oh, traditional system was mediation. No, not at all. There was lots more happening there. Whether women got a voice, whether women came in as mediators, whether they came in as participants also, that aspect also was something that I think, again, like I said, James Magarere, I think, is working on that sensitization also. But Jenny, do you want to come in here at this stage, or anything that you want to put in?
And I think you're absolutely right, Vikram, around the role of community, which has changed through the colonization, and that the idea of decolonizing mediation and restorative practices is to bring them back to their community roots and to get things away from systems to the extent that's possible, and keep things at the earliest, lowest level without having to, but you're, and Victor, that whole idea around, Law and Order, the TV shows, the culture. I mean, it's much more exciting, and the whole legal world has been really glamorized. And there was a brief TV show in the US on the Mediator, and it's just not, it's so nuanced, and so it's not, doesn't make good TV what we do. And so yeah, you're right, that is the what everybody wants. I've got to go to court. They don't say, oh no, I need to sit and work this out. I need to find a way to get along with my neighbor, or to get along with my coworker, or and so we really do have that culture that has been imposed around the adversarial process. And so how do we, and I really feel that community mediation, by saying that everyone can learn these skills and help others, and that people have these skills innately in many ways, that everyone can listen, and you can learn that kids can sit in circle and learn to hear each other.
But what I'm going to do right now, Jenny, is with the comments that have come in, let me just take them up. Tabitha says, food for thought, Jenny. Brenda says, wow. Then, of course, I asked Tabitha to come in, but she says, I'll listen, but I won't come in. Peter Singer says, how long do you think people will be reactive to the colonial influence, and what would need to be in place in order to mediate a new way forward? Tabitha, Victor, well spoken. Your view on the dominance of Western values resonates. Do you have recommended reading or listening for anyone who would like to educate themselves on the elaborative dispute resolution systems that existed before colonization in Kenya? So I think the other aspect that, of course, we will discuss and we should discuss is the aspect of decolonization in relation to the way the justice system worked. It doesn't work. Let's say it doesn't work. So the whole concept of not being able to deliver justice, because justice delayed is justice denied, and then to take care of your self-interest, going the direction of putting people into a forced system of mediation, which totally takes away from what mediation is supposed to be. The voluntary aspect goes away, and then you create this whole different things coming up in different countries, that whole mandatory mediation, this meeting and all that. With it, look, the foundation of that is incorrect, because the whole concept of mediation is totally different. And then again, this whole colonization mindset, that again dispute resolution through mediation also is being connected to courts, which I find the saddest thing to happen. We had an opportunity to move away from it. The most inefficient institution in every country is the judicial system. Backlog in some countries like ours, average 14 years, average. So you can imagine what the situation is. So in that kind of system, you can't deliver justice. You are going to now destroy another dispute resolution system, which was already done through colonization. We might have had some hope of it developing. Again, you're destroying it, and a lot of factors to it. I mean, I keep discussing this aspect of how it is now mediation connected to courts, connected to free, the mediator not being able to develop, but how do you develop in a free system? Free, not free in the free system, but free in the no cash involved system. All those things are also connected to that. So Victor, you want to address some of that?
I think in 2010, Kenyans adopted and promulgated a vibrant, robust, and a progressive constitution. To date, it has been lauded as one of the most progressive constitutions in the world. But that said and done, there are still, struggles here and there on implementing the constitution in spirit and letter. And I just want to make an inference of Article 259 of the Kenyan Constitution, which contemplates, an indigenous traditional mechanism way of looking at mediation. So of looking at mediation and dispute resolution. And I think you pointed out that we need to draw a boundary between traditional mechanisms of dispute resolution and mediation as we know today. So looking at it from a constitutional perspective, and this is in Kenya, my context here is Kenya, so I don't want somebody to throw my sentiments, out of context. From a Kenyan perspective, where I'm based right now, the Constitution has attempted, to decolonize our legal system. But then again, today you go to many mediation centers, and what they do is, court-mandated mediation, which is really, I think, going back to colonization. So the question here is, how do we really, cut our ties from our court systems, which I think it's going to be a process. It's not something that can be done. It's not something that can be done, quickly. It's going to be gradual and sequential because we are seeing efforts coming. When you and I'm really glad that you mentioned James Magerere. We are seeing efforts, develop on how to bring on board, for instance, experts on traditional mechanisms of dispute resolution, which is a good step, but definitely we need resources for that, because right now so much of our resources goes to adversarial, our judicial system, which is largely adversarial. We have little resource that has been invested even in mediation. So that tells you the role that resources play in implementing some of these good ideas. Then maybe the other thing would be a political commitment and willingness. At the end of the day, things come down to policymakers and the kind of policymakers that we have in the room. If the policymakers in the room are not excited, if they are not energized, if they don't feel an affinity towards, some of these conversations that you and I and Jean are having, then at the end of the day, it means that zero resources would be allocated to traditional mechanisms of dispute resolution. So that tells you that resources play a significant role in that process. That's how I look at it.
But let me tell you, Victor, of course, let me also tell Jenny about the symposium last year symposium, why I like to talk about it, because it was called the Woodstock of Mediation, 97 speakers, 45 countries. So I like to talk about that. And I hope people don't mind that. So, but in that session, in that symposium, we had James Mangareri, who's in Kenya, and he gave us an example of what happened there. He said there was a murder which took place in a community there, and that community within themselves resolved it, and the victim's family was told to was given some 15 camels. So thing resolved, finished. But obviously the police had to get involved, of course, the colonizers penal code. So they, of course, they filed a case, but no witnesses came in, no complainant. It went into the court. The judge understood from this aspect that the community has resolved it. So it told the police to go down, find out how they resolved it, and passed a judgment on that basis. So major controversy in Kenya, that how could he do it? We have a penal code, we have procedures. How could you do that? So it came down that the constitution supported that. So obviously, maybe Victor can talk about that, but the constitution supported this aspect, that what the traditional community is how they resolved it is actually endorsed by the constitution, which is a big thing. And this is something which can be taken up in various countries, because there are indigenous communities, there are traditional methods of dispute resolution everywhere. So of course, that also needs to be discussed. So that aspect, Victor, do you want to, have I got it right, first of all? And how do you look at that?
You got it perfectly right, and that's a precedent that is being currently discussed, in judicial circles, because there's a recent incident where a sitting member of parliament in a club, shot a DJ, and of course the matter, because of the penal nature of what happened, the matter ended up in a criminal court. And fast forward 2 years down the line, there was an arrangement between the offender and the victim, and the matter was settled, out of court, where we have seen the offender compensate the family of the victim, and just try to see to it that his livelihood has been compensated, and things of that sort. So we are beginning to see some sense of, traditional mechanisms are taking shape within our judicial institutions. But nonetheless, the public has been very, if you look at the public response, because at the end of the day, every other time we have a litigation, simultaneously we have a public court that tries to litigate some of these issues. Yeah. So in the public court, not so many people have been happy about that. So that tells you how still, as a society, we would rather stick with the judicial way, which is Western centric, of looking at things. But I have to say that this is a practice that is still developing. I wouldn't say that it's a norm. It's not a norm, but we're beginning to see a trajectory around that direction, even through our penal law, because our penal law does not provide for such kind of an arrangement where the victim and the offender get to sit down and reach an agreement that is mutually beneficial to both parties. Yeah, so it's a norm that is being tried. It's an experiment at this point in time. I'd like to call it as an experiment, but I'm really interested in looking at how things take shape, how we can have more such norms being adopted by our judiciary. And this is for various reasons. Our judiciary right now is burdened by, we have integrity issues. Our judiciary, as I speak, is battling with public confidence, public trust. So when you see such novel ideas adopted by the court, it tells you that definitely there are steps to decolonize.
But Jenny, do you see issues in this?
Well, just from the United States perspective, the 1964 Civil Rights Act is really what galvanized or made community mediation possible, this idea of taking the processes back into the community. And here in Minnesota, we had a circle process that the Minnesota Supreme Court upheld the decision made by the people sitting in the circle. So cases are referred as diversion to interrupt the school to prison pipeline, for example. So this idea that it doesn't have, things do not have to go through the criminal justice or the judicial system. The problem is it's not consistent. Who has access to it? Where are things held? There's a lot of inconsistencies right now. And I've talked, I've sort of been negative about the legal world, but there are some very interesting things happening in law schools. There is a mediation representation competition, and the competition word sounds kind of funny, but what happens is the law students are actually doing a mock mediation, and then after they're done, they go back and they're in pairs, and then they go back and talk with each other and come in, and they are to reflect on how well they worked with each other, how well they represented their clients, and how well they worked with the people on the other side of the table. And what would they have done differently? So the idea of incorporating reflective practice and the skills of mediation into the legal world is really changing how lawyers are doing things. It's amazing to watch that they are really saying, I'm here to work collaboratively on behalf of my clients. And so, and then that reflective practice piece is truly amazing. What would I do differently? And I've not seen that in the legal world before. And so hopefully it's happening in other areas, not just in the mediation representation. But that's one way of humanizing. I don't know if it's decolonizing because it's still within the structure of the system. So on the one hand, change the system. On the other hand, take it back into community. Can we do both of those things?
Yeah, those are questions we have to answer. But I think you just picked up that competition aspect. I just want to, of course, comment on that. Definitely this aspect that to collaborate and reflect and all that, I'm sure that's a good thing. But the problem that has happened in these competition is they've taken up that Western model, that Western box, and the whole format revolves around it. And someone somewhere started it in a certain way. All the children follow that same system. It all goes on that way. And the numbers in that kind of mediation are nothing compared to the numbers on the other side. So be it in the community and maybe lots of other mediations that take place, that's where the numbers are. And I won't get into that. I think that's a whole discussion on that part. But the important thing is that part that you said about collaboration and lawyers in their attitude, we had that discussion on collaborative practice, and that's where I told Mark was discussing that, and I said today we're talking about collaborative practice, and I'm saying that's what the legal profession was all about. It is, you don't have to, now we have to use the word collaborative practice because it's gone in a certain direction, and that's where we have to also put that across to the children, that this is the way the profession, the noble profession part of it was what it was supposed to be, and that is how you should take it forward. But again, a discussion for another, we have to put a topic for these discussions also. But Victor, you wanted to come in?
Thank you. I think one way to decolonize is we need to have more non-entrepreneurs, and I'm really glad that, you know, I'm really glad when Jenna alluded to the fact that we definitely need to contemplate a collaborative approaches to decolonization. And one way to look at this maybe would be just visiting history. You'll realize that traditional mechanisms of dispute resolutions are largely oral. And that's why today we are still trying to, you know, excavate indigenous history, because we were not good at writing things. We were not good at pen to paper, putting things pen to paper. So one way I think traditional dispute resolution mechanisms, or one way we can look at decolonization, is through a collaborative attempt where, yes, we are saying that indigenous dispute resolution is oral. And on the other hand, if you look at our judicial systems as introduced by our colonizers, they are largely structured, elaborate, and in writing. So we can borrow the whole concept of writing and registering things into permanent form. For instance, publication. So I see lots of collaboration in terms of that, on how we even structure this thing moving forward. How do we build precedents, for instance? Yeah. If you look at common law precedent, is very elaborate, it's structured, and it's primarily in writing. So there are certain things that when we study our current judicial systems, that we can benefit, or we can see indigenous forums of dispute resolution benefit from. That's just one way of looking at it. And this is to say that indigenous dispute making mechanisms can still flourish on these existing institutions and structures that we have. That's how I look at it.
On the precedent part of it, Victor, the thing that how I look at this precedent, because it does get discussed sometimes, and I keep saying, look, we have 8 billion, almost 8 billion people on this planet, and I think all of them are unique. Now, their dispute is unique. When they come together, that's a unique situation. They bring in a mediator who is unique. Now, this is a combination which is not going to happen again. So the solution that comes out of it is unique. To even say they should be looked at as a precedent, I don't think so. It is the parties, it's their way of looking at it, their thought process. So I am saying that let's keep that out of it. These common law things, again, that whole colonization aspect of it doesn't need to pass through every dispute resolution system. But let me, of course, of course, I put it down on my website also. 9th of August, we're having a symposium starts on indigenous peoples and mediation. So please participate in that. Please spread the word. Let's bring in people from indigenous communities to come in and talk about their methods and how things are functioning. Of course, let's see who all can come in who are actually working with those communities. So I'm putting that down here also. That's how I look at it. The other thing is, Tabitha asked you on reading, what reading that you recommend in relation to the dispute resolution system that existed before colonization in Kenya. Please, at some stage, either send it to me, or as you can send it to her. Please do that. So anything that, Jenny, you want to talk about on the aspect of precedent that he is talking about, precedent in terms of mediation, and of course the written part of it, and that structure and mediation?
I think, and I mentioned this early on, I think, Victor, before you joined us, that, the paperwork aspect of the traditional mediation has really become distancing. And that idea that, do you have, before we even get started, you have to read all of this and sign things. And if you can get rid of those trappings and just sit and have the conversation. And I've had mediators say, well, even if they don't reach an agreement, or if it's partial, I have to get something in writing. And it's like, but if they don't want that, whose agenda is it? And, and so that sense of being co-opted by the systems, even when you're operating in community. And how can we get rid of some of that? Some of my research looked at how mediators were using their skills informally in their daily lives, and they are mediating in their neighborhoods and their faith communities and their workplaces every day. And so we're all of these people that have been trained are using these skills informally without the need to have all of that, all of the trappings of mediation that we now have. And so, again, getting it back to the essence of what it is that this is all about, and having the people in the community own that process. and to not make an assumption that so that idea of doing more collaborative case development. What's important to you? Who should be there? Where would you like to do this? When would you like to do this? What would this look like? Who should be the mediators or the circle keepers? So really asking the participants rather than saying, well, you can show up at 2 o'clock and we'll have a mediation. And so where is the power and the decision making in what we do?
Okay, now, Jenny, the important thing, and for Victor, which is really important, is that the warm clothes that you're wearing is again rubbing salt in my wounds. It's gone up to 40. It's gone up to 41 degrees by this period that we've been talking. It's gone to 41 degrees centigrade here. But okay, now I think we need to also move into legislation, because that is what the colonizer did. So mediation legislation it's developing, or it is already there and has been there for some places for a long time. That also has brought in this aspect that the colonizer knows best for you. Who is going to be a mediator? The colonizer will put down qualifications. Why? It's their dispute. It's their mediator. But the colonizer had to have their foot into everything that you did. They want to get into your house. Who are you sitting with to resolve your dispute? So that aspect also, that whole conditioning has, of course, moved into that aspect also, which for me is very serious. How much is required in legislation? That also we need to discuss that. Okay, there is a concept of protecting confidentiality and without prejudice, because you are going to have courts and people are going to litigate, and in litigious countries like US, they're going to litigate a lot more. So in that sense, whether we need to protect certain things, let's look at that. So I mean, I'm saying a simple law, confidentiality without prejudice protected, by the mediator not being called as a witness, the settlement agreement as good as a court decree without going to court, stay away from the court totally. That's one way of looking at it, and that's the kind of simple legislation we have, of course, which is called conciliation, and that's perfectly all right with me, because that is mediation. So that part of it has also been to be looked at, because that the aspect of one, like I said, dispute resolution has to happen in courts, and the other thing, that the government has to have its control over everything you do. So in relation to mediation, do we want this? And is that the wrong direction it's going to? Or, I mean, your view, and this is my view I've put through, but what do you think, Victor?
We are yet to have a legislation in place, but one is definitely in the pipeline. And again, I just want to say that the legislation seems to be picking a homegrown perspective to mediation and, of course, indigenous dispute resolution mechanisms. And definitely, as you put it, the government needs to realize that we're living in times where the hand of the government is becoming less and less visible and conspicuous in so many things. And I agree with you that the government needs to just play a facilitative role. And by a facilitative role, I mean that it should create an environment that is conducive for indigenous dispute resolution making protocols to prosper, just the way as the government has, sort of, I don't want to say that they have facilitated our judicial systems to work, but I think that their role should only be constrained to creating a facilitative environment where we can have alternatives such as mediation prosper. And for that to exist, there needs to be resource. So again, the resource factor or component of promoting mediation and decolonization is one conversation that we cannot really run from. I don't know how the situation is in America, but down here, we're not seeing, that kind of a political commitment, just maybe to sponsor or to allocate resources towards indigenous dispute-making protocols and institutions. So like you put it, I totally agree. The government needs to, they need to refrain from, having their hands all over. So I totally agree to that extent.
Exactly. I mean, like I said, a legislation which brings in this aspect that we are the best to decide who will be your mediator. I think that by itself is the whole wrong direction that is gone into. But again, I'm moving away from traditional. So traditional is one part. The whole traditional, the way it was structured, that of course is one part. But in general, the way mediation has to develop. And this is where, again, the laws, that whole decolonization aspect of it, the which direction do we want that to move into, also we need to look at. But Jenny, do you want to, I mean, I mean, Victor wanted to look at the US experience on this aspect.
Well, and I think in terms of legislation, you have 50 different states with 50 different, and then every, municipality or judicial district. So there's no consistency in the US, unfortunately. And you're right, there is that need to be very controlling. And even here in Minnesota, with the calls to defund the police and to try to put those resources into alternate services, alternate ways of being, still are not happening. And so that the trappings of colonization are still very much present in day-to-day life. So I don't, and that need to shift those resources, because if you don't have the resources, but it tells you what's important, where the money goes, shows what's important to the system.
Yeah, because look, I tell you, in places now, of course, there's a discussion whether criminal matters should go for mediation. So we obviously have a session in the conference also on that. So now I look at it from this perspective that you say criminal matters have to be looked at through the penal code, and of course the colonizers penal code is there in a lot of countries. Of course, the Kenyan example of how the court looked at it and how the constitution endorsed it is, I think, something which is I've only looked at from the, I mean, I've only seen it in the Kenyan example. I don't know whether it exists somewhere else. So maybe in that symposium that we have it starts on 9th August, maybe we look at it. Because what we have to look at is that the colonizer gave you a structure where you could put someone behind bars. You could take someone's freedom like that. The police was your goon. You could do what you wanted with the police. The same acts, the police acts that the colonizer gave, they continued that because the goons of the colonizer became the goons of the government. So that continued. Now, to take someone's freedom even for 30 seconds, forget for years. We have people languishing in jails for years. They have, I mean, of course, they are innocent until proven guilty. So you put them behind bars. You cannot deliver. You cannot deliver. I mean, I'm talking about, we can give it the US example, you can give the Kenyan example, I'll come with the Indian example. There have been situations when someone has been put on the death penalty and has been finally acquitted by the Supreme Court. That person for years has been in jail, not knowing when he's going to be hanged. We hang, okay, Jenny, we hang. We don't have electric chairs and injections, we hang. The colonizer system, we still continue it. So to be able to put someone through that, now how could you do that for years? Someone going through that for years, you cannot deliver justice, but you keep the system to be able to put someone behind bars for years. And no one can question the judiciary because the colonizers institution can do what they want. They can get away with what they want, and they're on the pedestal. I mean, judges still sit on a pedestal here, and a high pedestal. Okay, high pedestal. Nothing has changed. In places like Nigeria, they still wear the wig and the robe. Here we wear the robe and the band. The same thing continues. So we have to question that aspect of the judiciary and that whole process, and how can mediation fit into criminal matters, which of course, if you can't deliver justice there, why are you holding back on this? Because the legislation, I mean, a bill has been put into parliament here where they want to exclude that. So those questions also have to be answered. You can't put someone through that process which you don't deliver on and still say that we want to keep people away from that process. So I think, Jenny, do you have examples in the US on criminal matters and how you see that?
Well, definitely using restorative practices, which are, we've talked about annexed, similar, but yet different, seems to be the way criminal matters are best, it's really not something for mediation. So different ways of doing it, but you're absolutely right. The system is so powerful that you really can't, you're using different methods to advocate for release, for, but that if things can be brought to the community through a circle, there's a wonderful story here in Minnesota where a woman whose son was murdered became, through a restorative practice, reconciled with the person who killed her son. And that took years for them to get to that place. And now that he has been released, they do talk about how restorative processes can augment or supplant the existing system. So the question is, who decides? And then people really, in the US, people are concerned with the idea of equal justice. And so people will say, well, this circle here will make a different decision than this circle over here. But the issue is that every court will make different decisions and every jury will make different decisions. So the restorative circles, restorative practices honor that, and they honor the people who are most directly affected, the people who were harmed, the people who caused the harm, and the people who have the responsibility for repairing the harm. So really different way of approaching it. And the state is not involved.
Yeah, I think also we have to, I mean, this whole very nicely people talk about the criminal justice system that let so many hundreds of guilty people go free, but no innocent man should be convicted. What are you doing by keeping them in jail? In a way, you've convicted them without convicting them. So they've gone through that. I mean, it'd be interesting. There's some cases in India where a person has spent more time in jail than if they were convicted on day one. Can you believe that?
Particularly if they have to pay fines or fees for being in jail and they can't do it. So it's an incredibly punitive system.
Yeah, and the colonizer, I mean, I'm still calling this colonization, okay? Colonizer doesn't want that to go to people. Colonizer wants that control. How can we give the people this whole opportunity to be able to within them sit together and take decisions? No, we have to be there somewhere because we can't deliver. We can't deliver. We know we can't deliver. That's why we want to push mediation through the court system, but we will also not let it go from our hands because we want that control. So that part, Victor, how do you look at this?
I love the trajectory that this conversation is taking. And at some point, maybe I'd like to make reference to South Africa, post-apartheid. If you look at the whole concept of the Truth, Justice and Reconciliation Commission, it was broadly centered on restorative justice. It was a people-centered approach on resolution, dispute resolution. And we have seen some elements of that play out in post-genocide Rwanda, where we had what they call as the Geshasa system. Geshasa is spelled as Gecaca, where the community sat down, the community created elaborate intentional structures that got to adjudicate over criminal issues. And then at the end of the day, we saw apologies are being made between the offenders and the victims. And there was a restoration of some sort of relationships within the society. And broadly looking at it from that perspective, which is an element of a mediation, which is all about having, relationships restored. So when you look at how, post-Rwanda sort of looked into the whole concept of, criminal justice system from a traditional element. If you look at what happened down in South Africa, that tells you that these mechanisms can be successful, but they can only be successful to the extent that the state is willing to play a facilitative role and allocate resources. And resources here are not just are limited to financial resources. Financial resources, go beyond that. It goes to the extent of providing expertise when, of course, the government is called upon. And we see these, it's a mechanism that is beginning to, all I'm trying to say is that it's a practice that is beginning to see the light at the end of the tunnel. So I don't know how other parts of the world are looking at it, but it's becoming an emerging practice in most African societies that have gone through civil wars and conflict. That is the way that most of these societies are looking at it. From a Kenyan perspective, we in 2000 and post 2007 and 2008, we almost had a similar scenario where there was a Truth, Justice and Reconciliation Commission that had to sit down, and all parties and all members of the societies, were called, and there was a national conversation on reconciliation. Yeah. So this is a practice that maybe needs to be taken to the next level. And by the next level, maybe we can legislate it. Within our criminal justice systems.
Look, Victor, the thing is, Jenny is just wanting to come in. I'll let her come in. Just give me 1 second. The point
I know
is,
we're just over time, but I want
no. I know you got to come in. No issue at all. What I'm trying to say is that these.
I just want to mention a
No,
colleague.
the moment restorative justice came in, Jenny unmuted herself. She's going to come. You're definitely going to come in. But all I'm saying is that this restorative justice, of course, from the healing perspective, definitely that's happening. But more of a role of that whole process needs to be also be looked at. And Jenny is, of course, working on that. So please, Jenny, how are you looking at expanding that?
I just wanted to give kudos to a colleague of mine, Ahmed Sirleaf, who created a truth and reconciliation process for Liberians here in the United States because of being here, it wasn't something that the Liberian government was involved with, but that idea of creating that process for Liberians living, particularly in Minnesota. So it can happen anywhere. And Ahmed is very much an advocate for the concept of transitional justice. And so that we're trying to transform the political systems. We're trying to change the way things are done. So, and that's something that's, it's like we have to take that back. It's not something that's going to be given.
Yeah. But Jenny, we have that discussion on role of mediators in restorative practice, because I'm looking at restorative justice still today is being looked at as a healing process. So of course, mediators have a role in it. So I'm just distinguishing between mediation and the role of mediators, because obviously both of them will go together. But to go more from restorative practice being a healing thing to more becoming a mediation, that aspect also maybe we can take up as a topic if you are wanting to discuss it and bring more people into it. So we can do that. So at this point, Jenny, do you want to closing remarks kind of thing? And Victor, you wanted to come in? You wanted to say something?
No, thank you.
So, okay. The Jenny, do you want to just closing? And of course, this is just a discussion to start with. Okay, we're going to expand on it as we go along. Yeah, Jenny.
Yeah, no, just thank you for this opportunity. I think this is a critically important topic and clearly something that warrants further discussion. I appreciate being included, and I've enjoyed working with Victor and of course you, Vikram.
Okay, thank you anyway. Thank you for coming in. It was really nice of you. Victor, please.
Thank you so much, Mediator Vikram, for what you do for the mediation community. You are becoming, a father figure within the mediation family, and we look, and we look forward to so many conversations that we'll be having more. Thank you for being, somebody that we can look up to, somebody that we can admire. Your zeal for mediation is just second to none, and we are grateful for what you do. And thank you to Jen for the lovely conversations that we have had. Definitely, I'd love to have Jen on this kind of a conversation in the future to come. So thank you so much.
Okay, so a good time to tell you, Victor, she likes to be called Jeannie. She likes to be called Jeannie. So,
Okay.
I mean, a little late, I'm telling you, but better late than never situation.
Those
So,
French names that are pronounced different in the US, right?
Oh, okay.
okay. So, Victor, kind words, nice words, being appreciated feels really nice. And like I said, you made my day, and I have a long day ahead of me. We have sessions in the evening. Please drop in. We have some
Sure.
interesting sessions coming in. What do we have sessions on? Let's just have a look one sec. We just, if you don't mind, can I take 2 minutes to put the schedule up there? A few people have.
Please do.
So basically, we have now. Let's just look at today. What do we have? So we have building the mediation muscle. Now, I don't know whether this will go through. Jenny, if you want to come part of it, Victor, because the person who had suggested is like she down with COVID, so well, I don't know whether she'd be able to make it. And like I said, maybe it's not good that she makes it because obviously must be tired and I'm sure. So free versus pro bono is a discussion that I really want that people should have and take it forward within their countries. That why are you doling out something free? Because people can afford it. They get lawyers into the picture who got paid huge fees. Why does the mediator have to suffer? Then the business of mediation. Victor, this is, I don't know whether Fola is from Nigeria, and Loretta, they're from Nigeria. I think Isaac is also going to join. He's in Ghana. So this seems to becoming an African thing. So please drop in. So this should be, of course, Fola is doing a lot of work in terms of, he calls himself a businessman first and then a lawyer. So please drop in. So thank you very much. And I'll just